Today we're going to talk about estate planning. And estate planning is basically where we want to control all of our property and assets. We want to protect our property and assets should we need nursing home care. And when we die, we want our property and assets, or as I like to say, our quote-unquote stuff, to be passed on to the people that we love without any unnecessary cost or delays. Now, when we do estate planning, we concentrate on you. Obviously, it's your estate. You get to decide who gets what and when. And maybe you want to give your beneficiaries a lump sum distribution all at once, or maybe you want to make installments, or have your beneficiaries only be entitled to income for fear that they're going to run off with all your hard-earned dollars after you pass away and maybe go to Vegas and gamble it away, or maybe go into Pittsburgh and buy themselves a nice Ferrari or Porsche, Mercedes. So maybe you want to control that distribution, and we can do that. That's an issue that we can discuss when we sit down to do your estate plan. Now, I want to ask a question, and I don't know if you'll know the answer or not, but what is the biggest enemy of proper estate planning? Well, the biggest enemy is procrastination. We all like to put it off and say, oh, I'll get to that will next week or next month, next year, and the next thing you know, 20 years, 30 years have gone by, and you don't have anything in place. You're not protected. So that's why we're going to talk about basic estate planning 101. These are the documents that everyone needs. For starters, let's talk about the durable power of attorneys for finance. Everyone needs a durable power of attorney. That is a document where you sit down and you name someone to act as your agent in the event that you become incapacitated or incompetent. Even though you may be married, some married couples may say, well, Tom, look, I don't need this power of attorney because if something happens to me, my husband or my wife has automatic authority to make decisions for me. And quite frankly, that's a common misunderstanding. Now, it may be true in some cases, such as a joint bank account, but let me give you a prime example from my life. Right now, my wife and I are in the process of selling our home. My name is on the deed. My wife, Stephanie, her name is on the deed. Well, heaven forbid if I were in a tragic accident and in a coma, and the very next day someone came along and offered to buy the house, the question is, would Stephanie be able to sell the house while I'm in a coma without a financial durable power of attorney? And the answer is no, she would not. And why is that? Well, it's because two signatures are required for that deed. My signature and Stephanie's signature. So, if I'm in a coma and I can't sign my name, there's no attorney, closing agent, real estate agent, notary, no one is going to turn their head and let my wife sign my name. Why? Because if I come to and I say, hey, who sold the house? I didn't sign that document. That's not my signature. What am I going to have? I'm going to have a very good lawsuit. Someone's going to get sued. That is why we need a financial power of attorney in place, which I have one in place, where I designate my wife to serve as my agent and to be able to make those important financial decisions in the event I do become incapacitated or incompetent. Now, let's say I didn't have that financial power of attorney in place. What would Stephanie have to go through? Well, Stephanie would have to go through what's called a guardianship proceeding. That's where Stephanie needs to go, find a doctor to testify in court that I am incapacitated or incompetent. Now, the court will then listen to this testimony and hopefully grant my wife the ability to sign my name and make decisions for me. Now, how long does that guardianship proceeding take? It typically takes between 90 to 120 days, and it can be quite costly. It can cost in the ballpark of $2,500 to $3,000, depending upon the attorney and the doctor's fees that are involved. Now, that's the financial durable power of attorney, and I want to make everyone aware that the laws have changed. As of April of 2000, there's a new updated financial power of attorney that is in place. Now, I'm not saying that your old financial power of attorney is invalid or that it won't work for you, but I am saying that there is a new and improved document. Now, what changes were made? Well, in 2000, the very first page of your power of attorney should read in big bold print at the very top of the page, notice. Then it goes down through and it should say that you agree to create this power of attorney pursuant to the laws of Pennsylvania. You sign it at the bottom, and then you go in the next page listing your agent and what powers he or she has. The other change is there is now an acknowledgement of agent form. That is a form where your agent must sign stating that he or she agrees to act as your agent and that he or she will act in your best interest pursuant again to the laws of Pennsylvania. Now, you may not think that this is a big deal. However, since 2000, what has happened? Well, all your banks and financial institutions, they're aware of the changes in the law. And if you take in an older power of attorney and they don't see the notice page, or maybe they don't see the acknowledgement of agent form, well, what are they going to do? Well, they're going to hesitate. They're going to say, I don't know if this document is valid or invalid. Then they're going to have to take that document, turn it into their legal department for review, and then how long is it going to take them to review it? I don't know, a day, a week, a month? You have a power of attorney in place. Why? Because you want your agent to be able to act immediately on your behalf. You do not want there to be any delays. So those are a few of the changes in regards to the law with a power of attorney. Also in those documents, you must be aware there are two ways to create the power of attorney. One is to have an immediate power of attorney. One is to have a two-doctor standard. It was known as a springing rule. It's still valid law today to use this two-doctor standard. However, with our firm, we don't prepare that document with the two-doctor standard. Basically, what this two-doctor standard says is that two doctors must put in writing that you're either incapacitated or incompetent before your agent has the ability to make decisions for you. Now, what's the problem there? HIPAA. HIPAA's the problem. HIPAA came along, and HIPAA's dealing with the Privacy Act. And today, doctors are both civilly and criminally liable if they release your medical documents to the wrong party. Therefore, I challenge anyone to go out and try to get two doctors to put in writing that you're incapacitated or incompetent. Now, quite frankly, if you're lucky enough to get those doctors to put it in writing, how long is it going to take? 2, 3, 4, 5, 6 weeks? I know that we have a client that recently had that old two-doctor standard, and it took them about 4 weeks to get two doctors to put in writing that mom was incapacitated. Now, that was a long time for her son, who was her agent, to not be able to make decisions on her behalf. It was a big problem. That's why we recommend to all of our clients to have an immediate power of attorney so that there's no question as to who can act on your behalf and when they can act.
For additional information on other topics regarding estate planning, please call us at 1-800-879-0984, or you can visit us on the web at www.shieldsandboris.com. The Elder Law Offices of Shields and Boris, helping you protect your family legacy.